Good morning to all the participants today. Welcome to 138 episode of AAA Weekly Webinar Series. Today, it's a special day for us as Dr. M.S. Sahu, former and founder chairperson of IBBI, has joined with us for special comments, for his expert comments. So, Dr. Sahu, आप हमारी ऑडियंस के साथ 1 मिनट के लिए इंटरेक्ट करिए. You can say.
Good morning to everyone. I am extremely pleased to be here. Deeply grateful to Mr. Goel for giving me this opportunity. And this is one of the ways of keeping myself updated. Since I left IBBI, I look for this kind of things where I get the right ready-made material for me to be in touch. Thank you. Please go ahead.
Thank you very much, Dr. Sahu, for joining this AAA Weekly Webinar Series. As my viewers, they probably know that 136 episode of AAA Weekly Webinar Series was also dedicated to Jet Airways, but that was in fact dedicated to the 7th November 2024 judgment of Honorable Supreme Court when this company was directed to be liquidated. So in that particular, we discussed various issues which in fact was decided by that particular judgment regarding the performance bank guarantee cannot be adjusted against the payment installments. Second, non-implementation of resolution plan by successful resolution applicant necessarily leads to consequences of liquidation. Timely implementation of resolution plan is very important. Then also the functioning of monitoring committee was necessitated. It was also a lot of suggestions were given by Honorable Supreme Court in that particular judgment dated 7th November 24. We discussed complete details of that particular judgment. We also said that 3 Supreme Court cases were filed. 5 implementation of resolution plan extension was given in that case. There were 5 issues were raised by State Bank of India, and finally, Honorable Supreme Court had decided that this company should be liquidated. Now, in today, what we are discussing in today's episode, that this entire fiasco of Jet Airways has given us a lot of learning, a lot of clarification, and also a kind of way forward in the insolvency path. But before I go forward, there is one part which was missed in the last episode, and that was the shortcomings and suggestions given by Honorable Chief Justice, the then Chief Justice of India, and those were suggestions. Let me go through briefly the suggestions given by Honorable Supreme Court, and that was basically one in a very generic form. That was kind of some flexibilities required in some timelines and deadlines, and also the monitoring mechanism. Then it was also suggested that the rigid deadlines and that should be a little kind of flexible. And then it was also argued that in fact, court said that the entire litigation of Jet Airways is an eye-opener for one and all. And therefore, before we close this matter, we deem it absolutely necessary to bring to light certain deficiencies in the IBC 2016, which require immediate attention. And this is basically the purpose of this was the boosting the IBC implementation. So the first such suggestion was that the central government or IBPI need to implement an independent oversight mechanism, possibly through an oversight committee, to enforce COC guidelines rather than leaving it as a self-regulatory measure. This step could ensure practical relevance and prevent lapses in decision making. This was the first very forceful suggestion by Supreme Court, and this will actually have an impact of robust enforcement mechanism would ensure greater adherence to best practices, promoting responsible decision making by the COC and safeguarding interest of the stakeholders. Also promoting transparency in the decision making process of committee of creditors. Now the suggestions that was given that also says the COC should record reasons for approving or rejecting a resolution plan. This will enable NCLT or NCLAT to understand a rationale behind COC's decision making and can avoid unwarranted interpretation and litigation. Then the another suggestion was curtailing unjustified extensions of timeline. The issue, like it was the issue which was raised, like there are a lot of granting of extensions. So the suggestions were that the Supreme Court, in fact, emphasized that the need to exercise greater scrutiny when considering extension requests, ensuring that they are granted only in exceptional circumstances with a clear justification. Then the most important was introducing statutory provision for a monitoring committee. Present issue is that there is no statutory mandate for a monitoring committee. Whatever powers monitoring committee gets, it gets from the order of NCLT approving the resolution plan. Suggestions, in fact, by the Honorable Supreme Court was that the legislative amendment in the IBC 2016 should be done, which include a provision for a mandatory constitution of monitoring committee. This committee, overseen by the COC, would ensure a smooth transition of the corporate debtor to the successful resolution applicant and monitor the implementation of the approved plan. This is actually a very, very important suggestion, and this will actually standardize the entire processes, and also the resolution plans will be effectively executed. So there are other deficiencies that was noted and that was also kind of highlighted by Honorable Supreme Court. One was the operational inefficiencies, procedural delays, and concerns about the domain expertise of the members within NCLT and NCLAT. So the suggestions in this regard from Honorable Supreme Court was more professional and robust approach towards case management within tribunals, including prioritizing timely hearing and ensuring adherence to judicial orders. It should include conducting proper and efficient virtual and in-court hearings, avoiding unnecessary adjournments, enforcing strict mandates for functioning within the normal working hour, addressing the issue of expertise. Now, the court says ensuring that the appointment of new members is done in a timely and seamless manner to avoid vacancies, and that the selection process prioritizes individuals with high integrity, proven expertise in insolvency law and procedures, and a strong track record of impartial decision making. That is what is the suggestion of Honorable Supreme Court. And the other suggestions are that the NCLT, while approving a resolution plan, should record the next steps that are to be taken by the respective parties for implementation of the approved plans. So with this suggestion, what I understand, the court is also saying that there can be conditions precedent and there can be conditions subsequent. So like when we see in the majority of the mergers and acquisition agreements, there are conditions precedent and there are conditions subsequent. So this particular, now the resolution plans will also, or rather can also have some conditions precedent and some conditions subsequent. So that is also an important, it's a very, very important suggestion. Now, NCLT has been directed by Honorable Supreme Court to adjudicate applications under the code in a time-bound manner by adhering to the timelines prescribed under the code and not to ignore requests for urgent listings and order passed by Supreme Court. The court, in fact, also highlighted that there should be adequate number of members to aid the insolvency reform initiative by the government. Also, quick identification uh, of the practical issues, and that should also improve quicker action. Supreme Court, in fact, emphasized that the IBC provisions should be applied with letter and spirit. So, with these suggestions, although the COC's commercial judgment is not at all kind of targeted, but yes, it is not immune from judicial interventions in case of there are non-compliances of any part of the uh, IPC code. So the Supreme Court also limits the scope of the kind of interference, but yes, it is not something which is not to be interfered. Interference only when there is a non-compliance. So these are various suggestions. So Dr. Sahu, what you would say on these suggestions before I shift to many other orders which are passed in Jet Airways, like Provident Fund, very many other things. So these are the suggestions on improving the IBC, sir.
Okay. Starting from the last point you made, the capacity at NCLT. I think we have to look at how these organizations have evolved, regulators and regulatory tribunals. What essentially we have done is we pushed away some work from the traditional judiciary to tribunal, from the traditional executive to legislature. But we didn't want to lose control of these organizations. We wanted that those who are no more by law, they are not eligible to continue in courts, they can come to tribunals. And similarly, those who are not eligible to continue in bureaucracy, they can come to regulatory bodies. And both of these have also mix of some judicial people, some technical people. And the recruitment rules are designed to ensure that these two bodies, tribunals and regulators, they end up with mostly this set of people. If you have a recruitment rule that people can come only for a 3-year term, you won't get better people. You can keep on asking that people with commercial expertise, judicial, all those things, eligibility, all those high quality things we should have. You can't have with this kind of recruitment rules stopped with the kind of a salary you pay. If you take the people like you and me and many others also who are doing very well in the profession, none of them, there are always exceptions who want to, out of patriotism, they want to do. But rare people would be interested to come to these places. No one comes, no senior advocate doing good business comes to High Court for a term of 3 years or 5 years. So you have to really get into the, even if state can't pay more, should not pay more, okay, you can't pay differently, much differently than you pay the judges and the other bureaucrats. But even then people will be willing to come if you give them a decent offer that at least you come, like in UK, US, they have the term of 14 years. The bankrupt judge sits for 14 years, and then also usually he gets a further time. So you have to revisit the recruitment rules for all tribunals. Similar also, it equally apply to regulators if you want to have some good quality people. Otherwise, you have to live with this kind of people who are coming out of courts and bureaucracy. They will become technical members, they will become judicial members, and they all will learn here what is IBC, and in 3 to 4 years time they learn something and then they will move out. So that is at the root of the problem. There are, of course, the immediate solutions is you need many more members. In fact, one working I had done back up the envelope working, and I had written that also in the press, newspaper articles also I have written, that if I just take the US standard, that means US has a system called, they have a GAO, Government Accountability Office, which is the counterpart of our CAG. That does work study analysis, motions analysis, and comes out to a figure that then they say that, okay, to deal with an individual insolvency matter, the judge needs to give 12 minutes of court time. For a corporate insolvency of this scale, this much of court time. And judge has to give 50% of time in court, 50% outside court. He works 48 hours a week. So all those things taking into account, they have decided how many bankruptcy judges they need in the country. If I just copy paste the same norms, they operate in a much higher efficiency level because of technology, because of scheduling, so many things, support system. We don't have all that. But even then, I assume that our individual insolvency takes the same time as their mandated 12 minutes or so. If I do a calculation of the current existing workload of NCLT, and that too ours is division bench, we have 2 people. In US, it is 1 bench, or 1 person bench. In fact, when we say that it is a commercial matter, why do you need 2 people to decide? People are deciding. You have to see whether meeting was held, votes were cast, notices were given, these routine things you have to see. Why do you need 2 people and waste time and in the process you delay the things? So you can just double up your capacity today with whatever 60 members you have. Today you have 30 benches, it can be 60 right away without any change in the law. It is possible to do it also. Some minor tweaking is required. So if I adopt US standard for the current workload, we need 360 judges, assuming the division bench, 2 people bench. If you have single bench, you can do with 180 of the current workload. But if you want to run this workload with 50 people, 60 people, with the additional work of Companies Act, naturally you will have problems. And not that alone will solve the problem, but that is an immediate need that just put more members there. In any case, you are taking members for 3 years. Supposing if there is no workflow, after 3 years, they all are going away. Does not add to any liability. So immediate solution is increase the number, but long-term solutions are you to look at recruitment rules to get quality people, get use of technology, get all administrative improvements, several administrative improvements. So just telling that NC people will come, quality people will come to NCLT, selection process should be good. You can have selection process, but where are the people to come? Does not work out actually. We have to be on the ground what encourages people to come for these public positions. There are always exceptions.
I think this analysis actually, in case some lawmakers are listening to it, like as against 360, which as per the US standards, this particular time we have only 45 or 50. So that's a huge gap, and the lawmakers should listen to this, that this is the immediate action required. Also, in case there is a possibility of larger timeline or extension, 2 or 3 or 4 extensions possible based on the performance of a person, then people at the age of 50 will also come. So that's very, very important.
No, extension is a very bad idea. Okay. Extension is a very bad idea. You come for 3 years and then you depend on somebody's mercy to get extension. So that will not allow you to work impartially, independently. I have seen that's a why do you think
presently it is not even extendable? Or
no, I think it's extendable. It's extendable. People are getting extensions, but they don't have enough age to get extension.
Yes.
They hit 65, 67 or 70. They don't have enough age, but it is extendable. But extension is a bad idea. If you recall, there was a law in 2005, National Tax Tribunal, something was there, 2005 Act. the entire act was struck down by the Supreme Court only on this ground that you revenue department people, where you are a party and you will transfer these members, you will give extension to these members. So Supreme Court did not accept that. So if you have this act, then why you think within the regulatory bodies and all regulatory tribunals, the extension provision is there, but still you do not get people below 60. You get rare persons, there are always exceptions. Rare persons coming to these positions. Because you are telling that your performance I will assess and I will give you extension. Whatever you want to assess me before taking me in. You do not assess a High Court or Supreme Court every 1 year, 2 years, or you don't assess an IS officer every 1 year, 2 years, whether to continue him, retain him in the job or not. You can have performance appraisal, but not for giving extension. So this is extension is a bad idea actually. People should come at the age of 35, 40 to these NCLT benches or so. And possibly some of them can also go to further higher judiciary. That option should also be there.
So one, that there is no possibility of promotion as of now. So therefore, the people are not coming. Anyone who actually further aspires something in life doesn't come here. So it is almost kind of like the last job of most of the people. It is the last job that they are doing.
Yeah, so exactly. So promotion also not a kind of you have time-bound promotion for civil service.
Yeah.
You can have promotions in the line like today we have in High Court or Supreme Court.
Yes.
But they come for the entire career. Irrespective, they come at 35, 40, 55. They will be there up to 65, 60, whatever you allow. They will be up to that time. You make that change alone, it will get many young people to come in.
Yes. So thank you very much. Coming back to our main subject today, like this, we have now seen the shortcomings, and now we move on to the other subject that we wanted to discuss today. What are the various other important judgments from Honorable Supreme Court or NCLAT, which has actually been gone through this Jet Airways fiasco? No, see, immediately after this, it comes to our information like the Jalan Farij Consortium versus Regional Provident Fund Commissioner and others. That is the judgment which is delivered by Honorable Supreme Court on 30th of January 2023. However, this particular judgment simply upheld the NCLAT orders passed on 21st of October 2022, and also some clarification and order that is on 2nd of December 2022. In fact, there are 8 applications filed before NCLAT, and in all the 8 applications, we have the order. This is one order for all the 8 applications. So the first application was filed by the Provident Fund Department, and they were in fact challenging that the EPF dues are not provided for in the resolution plan. The second application was filed by the Association of Workmen, and that Association of Workmen was challenging. In fact, that was the appeal by the Association of Workmen Aircraft Maintenance Engineers. And another Bhartiya Kamgar Sena is again a registered trade union, and for the Jet Airways Cabin Crew Association. So they were challenging their rights as workmen. Their rights were as like their unpaid salaries, lack of work allocation despite a willingness to work during CIRP period. Then another application was filed by 43 engineers previously employed by the Jet Airways, and they were asking for full payment of gratuity up to the date of CIRP commencement or their date of resignation, whichever is later. Then there was the other application which was filed by All India Jet Airways Officers and Staff Association, and they were also asking for compensate employees for earning wages and also for the leave encashment and retrenchment benefits. Another application was filed by Jet Aircraft Maintenance Engineers Welfare Association, a trade union representing them, they were actually saying that the adequacy of the admitted claims and the treatment of the employees' dues. Then an application was filed by Department of State Tax to challenge the approval of the resolution plan, where they did not include the payment towards the department's admitted claims to the extent of 56 crores. And the last application was filed by one of the operational creditors, Concor Air Limited, where the total claim was 82 lakhs, and he was equated with all the operational creditors by just offering 15,000 rupees to each operational creditor. So these were all the applications which were filed before the Honorable ANCLAT, and this ANCLAT order, which was dated 21st of October 2022, in fact, how it finally decided all these matters. How all these final matters were decided, which are very, very important, regarding provident fund, gratuity, regarding the allocation of the proceeds based on the security. So there are many judgments, in fact, that is a kind of conclusive judgments in this case. One overview of this judgment, which I can say as a very brief one, that it is minimal judicial intervention was again reiterated in this judgment by ANCLAT, Honorable Justice Ashok Bhushan, and also restricting the scope of review to ensure compliance under Section 30, subsection 2 of the Code. Now the judgment clarifies. This ANCLAT judgment, which is upheld by Honorable Supreme Court, clarifies that the employees are entitled to receive their full provident fund and gratuity dues, upholding previous 3-member bench of ANCLAT. Then ANCLAT also emphasizes that these dues are not subject to waterfall mechanism under Section 53, subsection 1, even though they are excluded from the liquidation estate under Section 36, subsection 4. ANCLAT also held further that the sales tax department's claim for secured creditor, the state tax department's claim as a secured creditor cannot be accepted, because their claim was under Maharashtra GST Act 2017, and there is a specific provision in the GST that in IBC, under IBC, they will not have any right. So the IBC will prevail. That is what is specifically provided in the GST law. Then the 15,000 rupees to each operational creditor was justified in this. It was considered as valid. Then the judgment also directs that the Regional Provident Fund Commissioner's claim should be, which was admitted but not included in the resolution plan. So that was also said, yes, it should be included. Now, the questions of law, these are the questions of law that I have said, all these questions of law, and in fact, many other questions of law, like in one particular question which was raised, that during CIRP, the entire workforce was in fact divided into two parts. One part of about 50 workmen, they were transferred to another subsidiary company of Jet Airways called AGSL, and that particular employee, they were called as asset protection team. So this asset protection team, they were in fact dealt separately because they were important for protecting the assets of the company, and they were transferred to another subsidiary company. So this was also a kind of challenge before ANCLAT, see how the workman was divided into two parts. And this other, which is very important, that the workmen claimed about 750 crores of rupees as a CIRP cost. They were saying that they were on the roll of the company, and they continued to be on the roll of the company during CIRP period. And then the no work, no rule should not be applicable to them, because see, they are in fact not given job. They are ready to work, but they were not given the assignment of working. So therefore, their salary is due. Then the another, which is very important, that while computing the payment to secured financial creditors under Section 53, subsection 1 and clause B, only the value of their security interest has to be taken into consideration, or their entire financial debt is to be considered while computing their entitlement of distribution of resolution proceeds. This is very important, although this is not fully decided because this matter is pending before Honorable Supreme Court. But this is also another important issue. Then in this particular judgment, for the first time, a contingent or a conditional resolution plan was accepted. It is basically in view of the law laid down by Honorable Supreme Court in ABIX Singapore Private Limited versus COC of Educomp Solutions Limited. That is also, in fact, discussed in this case. And also, one important part is that the retrenchment compensation, in case the employees are retrenched during CIRP, whether they are entitled to retrenchment compensation or not, that is also very important decision. Now, the contentions, in fact, we would not go by the contentions of the appellant or contentions of the respondents. We would actually try to see what is the final argument and what is held by the Honorable NCLT. Now, NCLT is saying finally the very first question of law is decided as the what is the extent and limitation of the judicial review by the adjudicating authority and the appellate tribunal in the context of a resolution plan approved by COC with the requisite majority. Now, the observation and the reasoning given by NCLAT, the court, in fact, again stressed the paramountcy of the COC's commercial wisdom and discouraged courts from substituting their judgment for business decisions. The reasoning that the court has given, one, that the statutory scheme delineates that a plan that meets Section 30, subsection 2 requirements cannot be approved. The connotation is that when the plan does not meet the requirement of Section 30, subsection 2, it need not be approved. The judgment of Honorable Supreme Court in the case of K. Shashidharan versus Indian Overseas Bank, dealing with the functions of the adjudicating authority after receipt of the proposal from the resolution professional for approval of a plan, the court affirmed the COC's commercial wisdom as paramount, urging courts to refrain from second-guessing business decision. The second-guessing business decisions, the court cannot think that the COC has taken a decision which could have been better. So that kind of second-guessing decision, business decisions, is not something which is in the powers of the adjudicating authority unless there is a complete violation of some of the provisions. So therefore, the decision of NCLAT was, it is settled that the commercial wisdom of the Committee of Creditors in approving the resolution plan is not to interfere in exercise of the judicial jurisdiction. So now, except in the cases where the resolution plan violates mandatory requirements as provided under Section 30, subsection 2. Now, this was the first question of law. The second question of law was regarding the workman dues on provident fund and gratuity. And in this particular case, let us see what are the observations of Honorable Supreme Court. The Honorable Supreme Court, in fact, it says that Section 36, subsection 4 and clause A and subclause 3 says that assets owned by third party which are in possession of the corporate debtor, including all sums due to any workman or employee from the provident fund, pension fund, and the gratuity fund. So 36 subsection 4 says the following shall not be included in the liquidation as state assets and shall not be used for recovery in the liquidation. Now, this again, the court says that the court will go by. The court will go by their own judgments. One, in 2019, a judgment was given, State Bank of India versus Moser-Bear Karamchari Union, and that in fact held that the Provident Fund, Pension Fund, and Gratuity Fund are excluded from the liquidation estate. These funds are not subject to Section 53 waterfall mechanism. Then another judgment was in the name of Tourism Finance Corporation of India Limited versus Rainbow Paper Mills, and that was in again 2019. And in this particular case also, the NCLAT directed payment of full provident fund dues by the successful resolution applicant, upholding section 36 subsection 4. This particular judgment was also the Supreme Court dismissed the appeal filed against this judgment. So this particular judgment has also seen the kind of consent of the Honorable Supreme Court. Then there was another judgment by ANCLAT on the other bench. That was in the case of Sawan Godiwala, the liquidator of Lanco Infratech versus Apala Siva Kumar, and that is also a workers' dispute where the earlier judgment of Moserbeer was overturned, saying that if there are no funds in the provident fund or in the gratuity fund or in the superannuation fund, then the liquidator is not supposed to fill that fund with the appropriate amount. So this particular judgment is still under the Supreme Court scrutiny. However, there is a stay on the implementation of this judgment, and then still the Supreme Court has to give a judgment on this. Then another judgment, which is Regional Provident Fund Commissioner versus Vandana Garg. That is also a judgment which followed Sawan Godiwala. However, later on, the Sikandar Singh Jamuwal versus Vinay Talwar, this particular case, the ANCLAT again gave a judgment, and there was an appeal filed, and that was dismissed by Honorable Supreme Court. So the Honorable Supreme Court has given a kind of two consents that the payment of provident fund and the gratuity is mandatory and it is to be paid in full. And then another judgment which is referred by ANCLAT is Nitin Gupta versus Applied Electromagnetic Private Limited, again reiterated the obligation to pay provident fund and gratuity fund. So therefore, the one important part which ANCLAT held, we find ourselves bound to follow the 3-member bench judgment in Tourism Finance Corporation of India Limited versus Rainbow Paper Limited, where the directions were issued to SRA to release full provident fund and interest thereof in terms of Employee Provident Fund and Miscellaneous Provisions Act 1952, which judgment has also received approval by Honorable Supreme Court. So therefore, the Honorable Supreme Court decided that whatever is mentioned in section 326 and 327 of the Companies Act, that is not relevant. The workman dues as per section 53(1)(b), that of course along with the secured creditor, that is only restricted to their dues, but in those dues the provident fund, gratuity fund and superannuation fund would not be included. And then it also says that in the case of Sunil Kumar Jain versus Sundaresh Bhatt, the Honorable Supreme Court held that workmen's dues, including provident fund, gratuity fund and pension fund, must be excluded from the liquidation estate process and liquidation process under section 36 subsection 4 of the IBC. These funds, and there is a word written, these funds if available with the corporate debtor must be used to pay workmen and employees and cannot be distributed amongst other stakeholders. Now this court, ANCLAT, further clarifies what is the meaning of if available. So in the case of Sunil Kumar Jain versus Sundaresh Bhatt, the Supreme Court used word if available. That if available was almost matching with the judgment of Sawan Godiwala versus Apala Siva Kumar. But this bench again clarified that the section 53 subsection 1 does not apply to such excluded sums. While the phrase if any available refers to the existence of such funds, if it does not negate the entitlement of workmen and employees to these dues if funds are absent. Now, in this judgment, Honorable ANCLAT says that if available does not in fact negate the entitlement of workmen and employees. The funds may be available in whatever or the other manners also. So that is what is very, very important clarification. And finally, the court held that the provident fund, gratuity, and pension fund are not part of the liquidation estate. These dues must be paid in full and are not subject to any waterfall mechanism under Section 53, subsection 1 of the IBC. In conclusion, the workmen and employees are entitled to full payment of provident fund and gratuity dues up to the insolvency commencement date, and also the obligation falls on SRA following the approval of the resolution plan. In addition to 24 months workmen dues and any unpaid balance to provident fund, gratuity fund beyond what is provided in the resolution plan must be provided by SRA. That is one thing which is decided. So, Dr. Sahu, on this provident fund, gratuity, and superannuation fund, so there are so many judgments that this particular NCLAT has considered. After considering all these judgments, the meaning of even if available is also now negated. So it has almost reached finality. So your comment, please.
No, I think if all the judgments are saying saying only one and the same thing. Sorry. So the provision you cited, section 36, is saying that the liquidation estate does not include provident fund. That is, even if it is under your disposal, this is considered third party asset. Time being, for whatever reason, you have not been able to transfer it to the right place, or you have got the permission to keep the money with you. But that money may not be existing in a separate form. That is, all money within the organization is fungible. That money you have used somewhere. You may not have created a separate account in the balance sheet, but that resources are within the organization. And your job is, when you resolve a company, resolve or liquidate, you can't be playing around with others' money. This is their money. Keep it aside somewhere. Whenever it arises, whenever there's a claim, they will get it. You can't be planning that I will revive my company by using this money, or I will pay under waterfall by using this money. But what's the NCLT? You told that if available. But if that money is not available, let's say there is a company, we had say Gotiranga Minerals, that has a zero balance, absolutely no assets. Let's say, I don't know exactly, let's say that company owed 5 crores towards provident fund. So where do you keep it aside? If available means something should be available out of which you can take it out. If not available, there is nothing to take out. So nobody can be held responsible. You can go after the people who are managing, who didn't protect that money, or who allowed the money to disappear. Even you can think of the criminal actions also. So if available, meaning is that it is available in some form. If it is not available, no one can get it. So therefore, this money incidentally remains in your pocket, being fungible. It is used somewhere. So you can't be considering others' money to resolve your stress or give the dues under waterfall. So I don't see any inconsistency in any of these orders. All are saying only one and same thing. That's the purpose when you had that clauses in the waterfall, 12 months and 24 months, that the workmen have given a little special status. So provident fund comes even higher than that.
So this is almost decided now, Dr. Sahu, that the provident fund and the gratuity fund and superannuation fund has to be paid. And even if the secured creditors get nothing in some cases, but these workmen must be paid these three things. Even if there is no fund available in these funds, if maintained by the company, whatever assets are available, out of the proceeds of those assets, first these three things will be paid, and then any money will be distributed to secured creditors.
Availability of fund is only an accounting procedure.
Yes.
So that's not a substantive thing one has to bother about.
Yes. So quickly, I will go through other questions which are decided by the NCLAT judgment, and since another question is whether this resolution plan is not compliant because it has not provided Then the ANCLAT says that there is some undertaking which is given by SRA. So based on that undertaking, he is ready to take the additional load. So therefore, the resolution plan is compliant. And then another question which comes, and another question which is coming here is that the whether the resolution plan as approved by the adjudicating authority violates the provisions of section 30, subsection 2 and subclause E of the code, since it contravenes the provisions of Industrial Dispute Act 1947. It having not provided for retrenchment compensation to workmen and employees who were so entitled under section 25F and 25FF of the Industrial Dispute Act. Now, this 25F and 25FF says that there are certain preconditions before a workman or an employee can be retrenched, and that retrenchment compensation has to be paid first before they are retrenched. So this particular part, how it is finally observed and decided by Honorable ANCLAT, it is very important. The Honorable ANCLAT says that nobody is retrenched. Nobody is retrenched. So there is no applicability of a Retrenchment Compensation Act. Some people were working, some people are not working. So the people who were working, they would be paid salaries. The people who were not working, they will not be paid salaries, because that cannot constitute the CIRP cost, because the CIRP cost defines very clearly that if anything has to be considered as CIRP cost, then section 5 subsection 13 defines CIRP cost, and it includes any expenses incurred by RP for maintaining the corporate debtor as a going concern. So if any workman is actually working with the RP for maintaining the corporate debtor as a going concern, that is the only thing which can be considered as CIRP cost. And any workman who was on the roll, any employee who was on the roll of the company but is not working for the company to be kept as a going concern is not entitled to. So when the demerger of the employees was made, some of the employees were in fact entitled to job because they were working. So that particular demerger does not mean that we retrenched other persons. We did not retrench. So therefore, this is not Retrenchment Compensation Act is not applicable. So in this case, even ANCLAT also referred the judgment of Anil �𝐤𝐴 versus Sandesh Bhatt, which clarifies that only the wages and salaries of the workmen and employees who actively worked during the CIRP are to be considered as CIRP. This was in the case of ABG Shipyard. So this is also an important judgment of Honorable Supreme Court, which was applied by ANCLAT in this judgment. And finally, it was held that the resolution plan was not in any violation of any other law, because Industrial Dispute Act was, Retrenchment Compensation Act was not applicable in this case because nobody was retrenched. So this is also an important clarity that we actually have seen in this case. In this case, now the another judgment, another question is, while computing the payment to secured financial creditors under section 53 subsection 1 clause B, only the value of their security interest has to be taken into consideration, or their financial debt to be considered while computing their entitlement. So this is an issue which is pending before Honorable Supreme Court. However, ANCLAT says that the ANCLAT disagree with the appellant's interpretation. ANCLAT says that there is a judgment of ANCLAT itself in the case of Small Industries Development Bank of India versus Vivek Raheja, and the Supreme Court's decision in the case of India Resurgence ARC Private Limited versus Amit Metal Links. Based on this, the court rejected the appellant's argument that only the value of security interest should be considered when computing the entitlement of secured financial creditors. While this matter is pending before Honorable Supreme Court, the ANCLAT continues to take this stand that the entire debt of a secured creditor has to be considered for allocating the amount distributable to a secured creditor. The matter is pending in Supreme Court in the name of, this is in fact my case, Technology Development Board versus Anil Goel. It was decided by Honorable ANCLAT, where the ANCLAT said that the security interest, value of security interest, and the priority of charges would not be considered. Once the claim of a secured creditor is admitted, all are entitled to proportionate. So that particular judgment was challenged by Kotak Mahindra Bank versus Technology Development Bank, and that is pending before Supreme Court. And then there are further matters are getting tagged to this, and the Honorable Supreme Court has not yet decided on this. And the other issue, because the time is also moving on, the other issue is that whether the contingent and conditional resolution plan can be accepted. And as per the in fact view laid down by Honorable Supreme Court in the case of ABIX Singapore Private Limited versus the COC of EduComp Solutions. Now, in this particular case, the court actually held that the very important part of this judgment is the one second. So it was the conditions precedent in this plan was essential requirement for resuming aviation operations. So one condition in this particular resolution plan was that in case the AOC, which is aircraft operating certificate, is not given by the government, then the resolution plan will not be implemented and the SRA would have no obligation to implement the resolution plan. That was the condition which was accepted by adjudicating authority, and ANCLAT said that this particular condition precedent was in fact very, very essential for revival of the undertaking. Therefore, this was acceptable. Automatic withdrawal clause became redundant after COC approval. However, the ANCLAT also said that there is no automatic withdrawal. Like in case the license is not given, it will be adjudicated. So there is no automatic withdrawal which is possible. So in case there is any condition which is there in the resolution plan that would not be implemented automatically, that condition, whether that condition has been complied with or not, whether SRA has taken appropriate steps or not, that would be adjudicated by the adjudicating authority and it cannot be automatic. So operational creditors given 15,000 rupees each is all held as valid. For Provident Fund Commissioner will also be given damages. Full claim has to be given, including damages. And the GST law is not having any kind of right because the GST law itself provides the exemption, or rather, when the IBC prevails, that is provided in the GST law itself. So, Dr. Sahu, we can take some of the questions quickly because there are many people who actually have some questions. I would be reading some questions, and I would say that Mr. Santosh is saying that there should be a cadre of members of NCLT and NCLAT, also more number of members. Very apt point, sir, and he in fact is not asking any question, he's appreciating. Mr. Anil is asking, it's wonderful to have the genius and honest person like Dr. Sahu to hear his insights on improving IBC. I request let him comment on other aspects of Jet Airways also. Yes, sir. Now, actually, the audience is asking for your comments on Jet Airways, since all the law points have now been briefly said by me. Yes, sir.
I think you mentioned the last point was about the secured creditor.
Yes, sir. Yes, sir.
So there is a loan I have given. There are three creditors, and A has a security of 10% of the loan he has given. B has a security of 100% backing of security interest. Another has a 200% security interest. So do we think that all three are at the same level? I have the option to take away my secured asset out of the waterfall and sell it and realize it. And if I get more than my due, I am obliged to return it to the general pool.
Yes, yes.
But if there is a shortfall, for that shortfall, waterfall says that you come along with the other people, not with the secured creditors.
Yes.
I think sector, whatever clause or section it is, the secured creditors unpaid by from sale of the secured assets, they rank much lower. So law is very clear. When it defines secured creditor, it says a security interest. Security interest means as much interest you have. Three creditors having different kinds of security interest have the different treatment. And the law says that you can take away, sell it anywhere else. Extra money you have to refund, there is a shortage, come in the queue, but not along with the secured creditors. Law is absolutely clear that a secured creditor is secured to the extent of a security it has. And that is the international norm everywhere. And that is the reason why secured creditors do not sit in the committee of creditors, because their interest is already protected. So therefore, they should not sit in the committee of creditors. Only unsecured people whose interests are affected through the resolution plan, they vote in the American system. Because the difference is, when we say secured in America, most often they have 100% security. Here we say that we are a secured creditor, but when a company is going into liquidation, why are you getting only 2%? That means you so far told that you don't give any loan without security. You say that all 100% of my loans are secured, but actual security is only 2% you have. 90-80% for whatever reason is not there. I don't want to get in why that has happened, but actually you do not have a security to the extent of 90-80% in case of company is getting liquidated. And in that case, you can't be saying that I will get 100% of my claim on the top of everybody. So law is very clear, but we are using it in a very wrong way. And this is different from, as I told, international norms. So this is about the secured creditors. What other issues you want me to?
So one, Mr. Anil says, let us hear from Dr. Sahu his suggestions for improving IBC.
No, there is no end to that. That is actually not asking me anything specific. There are problems in the law, problems in implementation, problems with each of the participant in the game, starting from RP, COC, NCLT, resolution applicant, and many of them think that they are above the law, like that COC. When you have, this is a game, it's an orchestra. In an orchestra, everybody has to complement and have to complement as per rules. And assuming that everybody is playing the rules, then only you can run jointly, say relay race kind of thing. You can run jointly and finish by the timeline. If one of them becomes injured somewhere or pulls aside, does some problem, the game will never be over. This kind of extension is actually a hoax to me. Why should there be any extension at all? Once you say that, Supreme Court says it should be done only in exceptional cases. But Supreme Court does not know that in India, everyone is exceptional. We don't have any ordinary person here. No sector, no business, no individual is ordinary in India. Everybody, once you say exceptional, everybody finds out n reasons to justify that I am the unique, no one else is comparable to me and I must get that special treatment. I think either you decide no special treatment or everybody gets that special treatment. Why somebody will get special treatment? If you have a half a dozen cases where NCLT is supposed to see that process has begun, 180 days stroke 330 days, 90 days, all that things, 330 days happened. There is no application for extension. On 330th day, automatically NCLT should issue an order. CRP is closed, company's order into liquidation. And if there is a liquidation request also, don't agree to request. Why should there be request for extension? Absolutely no reason. 330 days is more than enough. The longer you have, like a jet Airways, continue for 3 years, ultimately you are saying company will die. And the longer you have the problem, that issue you told that during the CRP, whether employees will get salary. The assumption was that it will run as a going concern, it will get over in 6 months. So the liability does not balloon up that, which becomes almost impossible. Absolutely no extension. You do in a half a dozen cases, automatically companies order an NCLT or system should say on 330th day, company is hereby ordered into liquidation and so on, so is the appointed liquidator. Do in a half a dozen case, you will see that not have just 2 cases. No case will go beyond 330 days. When we did not have the capacity, we had not learned IBC. The very first one is Synergy Dure, and quite a few got completed in 180 days. But now we are not doing it because now we have known how to misuse IBC. Then we are trying to learn how to use IBC. We are completing in 180 days. Then we learned how to abuse IBC, and we don't allow it to complete it before 1000 days. So actually, this is a completely wrong approach to say that there should be an exceptional case. So supposing there are 100 cases, there can be exceptional 2 cases. It's better that we take a wrong decision and let these 2 also close along while the 98 are helped. So because you become exceptional in one case, you are giving that benefit to 100 and all 100 are suffering or all 100 are gaining. If you think it's a positive thing, good thing, give time to everybody. So no exceptions should be there. And as I told you, you have to play by the rules of the game. Everybody has to match step to what we call in a dance. Everybody's step must match to one another. And if you say that, no, I am something beyond the law, above the law, I will not play in a harmony. The COC has been exemplified here in this matter. COC is the decision-making authority. And it is their money, their stake. The rest are only guest artists in the drama or orchestra. Everyone else is there to assist the committee of creditors or creditors. IP is interested in fee, NCLT is interested in their salary, or somebody else, whatever waterfall things, people will get something. But it is the COC which has been given the authority and unusual powers. Unlike as I told you, elsewhere COC is non-secured creditors, but here we have given an undue privilege to creditors. And after giving that privilege, we are saying that you have no accountability, everyone else is accountable. If resolution plan goes back, he can be hanged. Everyone else is accountable, only you will not be part of the law because you are probably regulated somewhere else. So it does not work actually. And I always give an example that in the early days of securities market reforms, SEBI was created. SEBI was not having a jurisdiction over the companies, the listed companies. All that SEBI wanted to do is exact parallel of IBC. It used merchant banker, broker, some merchant banker particularly, as an intermediary. You are an intermediary. Please help me. Please ensure that listed company complies with these requirements because I can't give any direction to listed company. I can't look at their affairs. But since they are coming to market and you are bringing them, I will hold you liable if the company does not behave well. The outcome was we had hundreds of fly-by-night, the term came of fly-by-night operators in the 90s. So then when it became very painful, investors are losing money and it became a huge issue, SEBI was given the authority that henceforth you will have a jurisdiction over listed company only in respect of issue, trading, etc. for securities. It happened in 95, 25th of January 1995. From that date onwards, there has not been a single instance of fly-by operators. So I am not saying what great work SEBI did or has been able to do, but only this change that there is somebody who is watching you made a huge difference in the conduct. But if you keep nobody is watching you, you can do anything you like, nothing happens, you can't achieve the purpose. So therefore, everyone has to follow some rule of the law. You are playing a game, you have to follow the rules of the game. It equally applies to everyone, but what else you want me to comment, I will comment.
Sir, one advocate GP Madan is asking one specific question from you. Are PF dues get priority in case sale of assets under SURFACE?
No, you have to ask a SURFACE expert, because the idea is not that SURFACE and IBC, they will give similar treatment to stakeholders. We are in an economy where we call that an economy having economic freedom, market economy. every market participant has the freedom to make a choice. If he thinks A is better, he will go through that route. If he thinks B is better, he will prefer B. But authorities have given, you have surface I option, you have IBC option, you have some other option, you choose. But if you follow IBC route, this is the consequence, this is the approach. The resolution under the companies, under the IBC, for example, brings the benefit of improving entrepreneurship. Resolution under Surface I, resolution under RBI Producer, resolution under Companies Act does not give that benefit, because the manner the IBC is structured, it is structured to derive certain benefits. So in the IBC, the PF treatment is given a particular treatment. I don't know what to actually, I have no idea about Surface I, but Surface I may be giving a different treatment because the objective of Surface I is to achieve something else. So I have no idea on that.
So I can assist a little bit. See, in Surface E, we have section 26 capital E, where if the secured creditor has registered their lien on the asset in Surface, in the books of Surface, then there is no other claim possible on that particular asset. So that is very clear under section 26 capital E of the Surface law. The only condition is that this particular transaction of mortgage must be registered with Surface, that is Central Registry for Mortgages. So then there is no other claim, even if it is a government dues or a PF dues, that is nothing applicable. That's what is very important. One, Mr. Sunil Jain is asking one question from you, sir, whether the payment of CIRP cost is to be made by successful resolution applicant before payment of PF dues.
See, CIRP cost finds place as a part of the waterfall. PF dues is not a part of the waterfall. So PF dues is always above the whatever comes, whosoever comes on the waterfall.
Yes, yes, yes. That's very important. Then there are about 23 more questions. I don't think we have time, and we normally conclude within.
Someone is asking a small question about the notarization.
Yes, yes, yes.
I just wanted not to answer that, but I wanted to tell the why what happened was that when IBBI came up with the regulations, as you know, it came out with all regulations on 30th November within 60 days of its existence. And at that time, even IPs were not in existence. First set of IPs were registered on 30th. So we did not have market knowledge. IBBI quickly considered two committees. Based on their recommendations, regulations were drafted. And the regulations were drafted as notified on 30th November. Nothing has gone wrong and no change is required even today. That's perfectly fine. Actually, we didn't go wrong anywhere. In the very first set of regulations, CRP regulations notified on 30th November, told that these claim forms have to be notarized. But then that was the understanding. Law people guided, yes, that must be some sanctity. It was done. But the problem arose when JP Infra started. Thousands of people, they have to do everything in 10 days time. So everybody was looking for a notary around Noida. And I'm told that some people asked 20,000 rupees, 30,000 rupees to do this notarization. So when these things are brought to the notice of IBBI, IBBI did many things like that, giving that form, so many things to facilitate. And it used that occasion to do away the requirement of a notarization. So notarization has no value. There are some resistance from legal people at that time also, don't do away with that. But IBBI took a call. This is completely unwarranted and not required, imposes unnecessary cost. In any case, he is giving the details for verification by IP. And he has the company's records to verify. So why that guy should run around a notary? So notary concept is not there, notarization is not required.
Yes. Any other question which you would like to take up, sir?
You tell me whatever, I have no choice actually.
In fact, many questions. And in case you would still like to have a role of strategic investors like Jalan Calrock Consortium in the resolution of Jet Airways and how they influence the airline's potential revival. So what do you advise to resolution applicants, like as the Supreme Court has already said in their suggestions, that the resolution applicant must be a very, very dedicated and diligent, and also should comply with all the law, and should not be a very, very casual investor. That's what the Supreme Court. Would you like to add anything on this role of the RAs?
No, no. Actually, the law itself provides that a casual guy cannot come in. When he has put in 150 or 250 crore upfront, which will be forfeited, there is no question that a casual guy has come in just to throw away money. And he gave that 150 or 250 performance guarantee. And even to reach that stage, he must have spent maybe 50 crore, 100 crore to do due diligence and all professional, all work. So I don't think he was casual or not serious. Circumstances has become, or people could not anticipate these things. Law should provide for that, but not that we consider somebody as there were in some case, I am not remembering, there were casual resolution applicants at one time when this performance guarantee business was not there. That's why performance guarantee law was changed to bring this performance guarantee. So I don't think, and this is also not right to say that we will have a money. Today there is enough mechanism under the law which says that the RP shall verify and NCLT shall be satisfied that there is a perfect good arrangement to implement the plan. All those things are there actually. And the more you do that, it is their money, resolution applicants' money, creditors' money. They have decided this is will go through, our process will go through, it will be implemented like this. And they know also, they themselves can, if they want to monitor, today they are doing by practice a monitoring arrangement. But why do we want to mandate it and add to cost and create another set of parasites actually? What will happen is NCLT or whosoever is there, or this is a tendency actually. You put your someone you know who in that monitoring committee. The committee of creditors will come with 3 people. NCLT will add 1-2 more names. So actually, that's another hierarchy, another headache. I don't think we should get into the monitoring concept. Actually came up. The original is in the competition law, and CCI has recently formalized that arrangement. And that situation, that kind of complication, the rule of origin, the behavioral remedies which state wants are different than the concept of a private contracts. This is a private contract. Government, the state is only blessing that, okay, you have done things in a procedural way, you have not trampled on anybody's rights, go ahead. Thereafter, companies, theirs, money is theirs. Why should you want another person to sit there and monitor it? And as if you were saying that this committee of creditors do not know how to monitor it.
Yeah.
I don't think they are all unnecessary adding cost to that. In this form, you are actually the one way you are saying that we will not get into commercial wisdom, but you are still saying that let the judicial have also oversight on the commercial wisdom. So actually, this is we are talking in 2 different ways. Simply leave it to committee of creditors to decide. Only when you have evidence to say that committee of creditors have done some mischief, or let's say, and actually they have very little scope for mischief if the IP really stands strong. So voting required is 66%. It is IP to ensure that. And today there is a technology which is the recording what is the percentage of voting. The thing is left to COC actually. And you can't be asking the COC, write the reasons why you are taking this decision. Because it is a voting. You have a evaluation matrix. You are saying that let there be deliberation. Let deliberation cover feasibility and viability. After all that, it is confidential voting. Everybody has a different reason to vote for or against. You can't be asking me in an election which candidate I am voting and why I am voting. That's confidential. So the decision of the COC is as emerges from voting. You can record the deliberation. 10 people found this is feasible, very viable for the 10 reasons. 10 others didn't agree. Evaluation matrix told this, but people had different views. Record all those views. But the decision is flowing mechanically from a machine which does not give any reason. And if it has to be region-based, then it should have been decided in the meeting itself. Voting was not required. So voting means ideally voting is confidential, no reason is to be given. So I think the more you ask for the things, more rules you lay down, the more problems you are inviting. And more will be the responsibility of authorities. That amendment, that 30 section amendment which says that IPSL verified complies with the requirements, that should be fine. But then you say that NCLT should be satisfied that 32 has been, section 32 C or D, whatever has been followed. How does NCLT verify that all laws have been complied with? It has to depend only on RP certificate. So by giving this power to NCLT, you are saying that let NCLT poke its nose, waste more time into unproductive things. And if NCLT says this is, approves it, says that it is as per order, that means nobody can challenge it is as per order or not. Because NCLT has taken the call, everything in the plan is illegal. Because it is satisfied with the 32. So the more things you give on the authority, more problems you invite.
I would add this particular, the resolution applicants of Jet Airways, they have lost 350 crores plus whatever they have spent on professionals and lawyers, that I think they have already lost 400 crores. So they were not casual. The circumstances were like this. So they actually could not implement the resolution plan in time. So finally, the timely implementation is family, which has been held by Honorable Supreme Court, is mandatory. And also State Bank of India filed 5 reasons before Supreme Court of India that this resolution plan would not be implemented, so it is better to liquidate. So now I think although the questions are many and we have to close this episode, normally we have a time of 1 hour, but then today we have extended it to 1 hour 18 minutes. So thank you very much, Dr. Sahu, for appearing in this episode. You probably have seen how the questions are coming in to you, and as how the public likes you. And the comments that I have read is that we would like to hear the comments of a very, very honest and hardworking IBC professional. So that's what is the kind of aura that you have. You have a command over the profession. So thank you very much, Dr. Sahu, for appearing. Thank you, all the audience.
Thank you. But while you are citing the cases, you read out so and so and so and so. So that so and so is mostly an insolvency professional.
Yes.
So the case laws are coming up and immortalizing insolvency professionals.
Yes.
Thank you.
Thank you very much. Thank you very much. It is our way of learning. Thank you.